Hello and welcome back to Inside the Contract. We are still on season 2. This is episode number 7. In today's episode, we address a painful reality in FIDIC contract administration and one of the most common reasons claims fail on major projects. A contractor can be 100% entitled on the facts, yet still lose the entire claim because the procedure was not followed. In FIDIC 2017 introduced strict notice mechanisms and time bars to bring discipline to the claims process. These rules are not advisory. They are mandatory, and in practice, many tribunals and courts give serious weight to FIDIC's notice and time bar machinery, especially on sophisticated projects. So teams should assume these deadlines will be taken seriously. This episode explains why entitlement alone is not enough and why procedural compliance must be treated with the same seriousness as technical evidence. Every claim has two dimensions. First, substantive entitlement. This refers to the factual basis of the claim. Was the contractor delayed? Was the delay caused by the employer? Did the contractor incur extra cost? Was there a change, obstruction, or miscoordination, for example? Substantively, the contractor may have a strong case, clear, measurable delay, or undeniable employer-caused disruption. Okay? The second part of the equation is the procedural compliance. This refers to whether the contractor followed the contractual steps. Was notice submitted on time? Was the notice clearly identifiable as a contractual notice and delivered in the required manner? Were particulars submitted under clause 20.2.4? Were updates given monthly? Was mitigation demonstrated? If in FIDIC 2017, a contractor must satisfy both entitlement plus procedure. If either one fails, the claim may collapse. Okay? This is why even legitimate claims can be rejected entirely. Procedural discipline is a core component in the FIDIC risk framework. Okay? Clause 20.2.1 contains one of the most unforgiven deadlines in FIDIC. The contractor must notify the event or circumstance given rise to the claim within 28 days of becoming aware, or when it should have become aware of the event. Three critical points here. 1. The 28 days start early. The trigger is awareness of the event, not awareness of its impact. For example, receiving a late drawing often triggers the notice window immediately. Second, missing the deadline may time bar the entire claim. FIDIC uses the language, FIDIC uses strong time bar language, okay? Shall lose an entitlement. So you just be aware of this. And many decisions apply it strictly, subject, of course, to the governing law waiver and, case facts. Third, the burden is on the contractor to show they acted promptly and reasonably. The clause 20.2.1 is designed to stop contractors from accumulating historical claims and submitting them late in the project, which is a common problem in legacy projects. So what is, the legal view here? Strict versus flexible jurisdictions. The enforceability of a FIDIC time bar depends partly on the governing law and the region. How hard the time bar bites can depend on the governing law and the tribunal's approach. Some legal systems and tribunals lean toward enforcing contractual risk allocation as written. Others may give more room for good faith proportionality, waiver, or estoppel, or lack of prejudice. But the safe approach on major projects is to assume the time bar may be enforced and administer notices accordingly. However, even in flexible jurisdictions, tribunals increasingly lean toward FIDIC's intention. Okay, so discipline over leniency. On mega projects with sophisticated, parties and experienced engineers, tribunals are far more likely to enforce clause 20.2 strictly. Okay, so let's look, at an illustrative example to demonstrate the common patterns on some projects, especially here in the GCC region. On major projects in the GCC region, the employer delayed key design approvals. Contractor suffered real disruption and critical path delay. Entitlement on the facts was strong and undisputed, but the contractor submitted the clause 20.2.1 notice 45 days after becoming aware. The engineer rejected the claim immediately for late notice. The contractor escalated, arguing that the employer was responsible, no prejudice was caused, the delay was genuine, the engineer was informed informally. Okay? The decision is still upheld the time bar, stating contractors experienced in FIDIC must follow FIDIC procedures. Informal communication does not replace formal notice. Procedural obligations protect projects, transparency. Okay, so this illustration highlights the harsh reality, which is entitlement means nothing without compliance. Okay, so if someone asks, are there any exceptions under any circumstances? FIDIC 2017 provides very limited escape routes from the time bar. One, for example, engineer accepts late notice. Clause 20.2.1 allows the engineer to accept late notice if justified. However, engineers rarely exercise this discretion unless the contractor provides clear evidence of why delay was unavoidable, a proof of no prejudice to the employer. Second, employer waives the requirement. Waiver must be explicit or clearly demonstrated through conduct. Decision makers require strong proof. Casual email exchanges are insufficient. 3. Exceptional circumstances. In extreme situations, the debate is usually not the deadline disappears, it is whether late notice is justified, whether discretion is exercised, whether the other party waived the point, or whether governing law limits enforcement in these circumstances. Okay? But these are rare and difficult to justify without robust documentations. Okay? Realistically, these exceptions exist more in theory than in practice, guys. So relying on them is high risk and often unsuccessful. So what are the best practices for contractors? Again, to repeat what we have talked about before. Contractors who excel in FIDIC administration recognize that procedure equals protection. The key practical practices include submit notices early, even incomplete ones. You can supplement particulars under the contracts, claim particular process later. Train site teams. The biggest risk is delayed awareness. Site engineers must know what constitutes a claim event, how to escalate internally, how to log the trigger date. 3. Maintain a live claim register. This is essential for tracking deadlines, monitoring events, ensuring procedural compliance. 4. Never rely on fairness alone. FIDIC's structure prioritizes timely written contractual compliance over subjective fairness. Contractors who adopt these disciplines win more claims, not because their entitlement is better, but because their procedure is stronger. Okay? The moral of the story is simple, but critical. Entitlement without procedural compliance equals failure. You can have the perfect evidence, clear disruption, and strong technical case, but without proper notice, your claim may collapse instantly. FIDIC 2017 is designed to ensure both parties communicate early, manage risk proactively, and avoid surprise claims. Okay, this is also a big deal. Procedural discipline is not a bureaucratic burden, it is a contractual safeguard. Okay? So, to close, remember, it is not how justified the claims are, but on how well they follow the process, the formal process. This is the message. Following the procedure is as important as the technical details of your claim. Okay? By this, we come to the conclusion of episode 7. I would like to thank you for watching, again, as usual. In the next episode, we tackle another difficult issue: how to distinguish true exceptional events from normal commercial risk, and how to avoid misclassifying your claims in this regard. Okay? Again, thank you. See you next time.